I want to make sure that it was the assumed business name and not the trade name that we need to be getting.
Cut to the chase, man. You stand on that damn act I've been telling everybody about. Everybody I'm talking to, I talk about that act. That bottom line, they have to have evidence in order to get involved anyway. If they don't have no evidence that you are a danger to that child, or any decisions you making toward concerning your upbringing of that child is a danger to that child's life, and or physical can result in physical harm to that child. If they don't have evidence, compelling evidence to prove that, then they don't have jurisdiction and get involved.
Okay. That's
an act I didn't know. I didn't even know it existed until like 2 months ago. I was doing some research and found that shit. And the thing is, I remember when it just caused me to reflect back in my case. I'm thinking it has to do with registering the name. It may have played a role in it, but at the same time, it's a possibility that it did not, because I know people that beat child support without registering the name. So it's not the only way to beat it. So, but another thing that I realized in my own case is the fact that my son's mom made an accusation about me. Of course, I called him out on that. I rebutted it, and I'm like, there was no evidence for that. And I continued to rebut anything they ever said, because there was no evidence to prove anything they were saying. And they didn't have no authority they don't have no authority to use my social security number, any number that's connected to that name that only I'm authorized to use. They don't have authority to use it. So the state can't intervene in your private matters unless they have compelling evidence that you are a danger to that child. Then they can intervene after they can obtain an interest in that matter. Other than that, they can't get involved.
Okay.
And that's what really shut them down, because I was completely rebellious, and they had no evidence to get involved. At first, they called themselves tried at first, and the very first hearing that I had, that judge signed a temporary like a temporary stay-away order. I forgot what they call it. Temporary. Anyway, it was more like a stay-away order. Like a restraining order. Yeah, it's like that. But everything that was worded in there is basically talking about basically steering clear from her and the child. And it was because of an accusation that they used. I rebutted that order too, because I'm like, there is no evidence that I did any damn thing wrong. None whatsoever. I called that out. Only thing was, I didn't know anything about that act at all. But I did know they didn't have evidence to prove anything they said that would give them right to even sign an order for me to not communicate with her or my child at all. And so so I rebutted that, and I responded to it in writing. I made sure I did that. Now, and I did that repeatedly. And I even called my man and tried to force them to put some evidence on the record. Put evidence on the record that I'm actually this monster y'all trying to paint this picture about. And they never did that. Of course they didn't do it because the evidence don't exist. Okay. Now, with that being said, me calling them on that, they never could do that. Now, keep in mind, I never did, I wouldn't go around her house, because I knew they were trying to get me locked up at one time already. But I still would call her. I still would text her a few times, trying to communicate with her privately, trying to come to some type of agreement or whatever. Now, if that order had any type of validation, if it had any type of power, I would have got in trouble for communicating with her. I sent her a text. I left voice messages on her phone. So that lets you know that order was a sham order. It was a bullshit ass order. They didn't have authority to make me not say shit to my child's mother when they have no evidence to prove anything. I never got in trouble for texting this chick or sending her any type of. I called her phone and I didn't block the number. I called her phone and left voice messages. She never would answer the call. And I never left nothing, of course I didn't leave no threatening message or something. I wasn't talking crazy. Yeah. The thing is, I was talking to her trying to, sensibly. And so, even so, I'm sure she played back those messages to her attorney. I'm sure she did that, because they thought that since this order was put in place, they were thinking that them not knowing the law, they would think that the courts would have authority to do something to me because I sent her a message. You know what I'm saying? Or because I called or texted her phone. But they didn't have authority to do anything. I never got in trouble for it, not once. You know, that's proof that act was already put in place, and they were aware of that act. But I didn't know, I wasn't aware of that act. But I did call them out on evidence. Where's the evidence? You can't make empty accusations. They're baseless accusations about me concerning my child, and not have evidence about it. Not have evidence to prove what you're saying. Because if you don't have evidence, I don't give a damn if you're the president of the United States. You don't have authority to get involved in a private matter. That is a private matter. All of y'all took an oath to the Constitution, and you have everybody, and that's covered in the Constitution. Everybody has a right to privacy. You have a right to privacy, and that's part of the same thing.
That act, what's that?
The Parental Rights and Responsibilities Act of 1995. Look that act up. I'm telling everybody about that act. Go back and listen to some of my videos I posted on YouTube. And I posted some recent videos past month or two on that talking about that act. When I'm having discussions like this one I'm having with you, I'm gonna post this on the internet. I'm putting it on there so people can hear what I'm saying. That act was something serious. They put those officials in check. It keeps them in check, and it says in that act that you can cite. You can raise that act as a defense or a defense or a claim in any court proceeding.
Okay.
So you can, and it specifically says that the officials, the courts have to have compelling evidence that the decisions that you're making concerning raising your child can result in a physical harm to that child, or it's a threat to that child's life.
Okay.
If they don't have that evidence, they don't have jurisdiction to get involved. They can't force you into no damn child support contract. That's getting involved. That's taking interest in a private matter. You don't have control. You don't have jurisdiction to do that. They always say we have jurisdiction, but nobody ever calls them out on that. They don't use that act in their paperwork. That act is something vital. It keeps them in check.
Yeah, I'm looking at it now.
So I'm thinking all this time, maybe me registering my name and separating myself from the all caps name is what beat the thing. But it's a good chance that it might not be the thing that caused me to beat my case. It may be a good chance that it may not have nothing to do with that, because I've known people to beat child support without separating the name. Putting all type of separation from them in the name. You know what I'm saying? You have to bring the right argument, and there's many ways to beat these cases because they don't have jurisdiction to get involved in private matters. That violates the Constitution and that act. And they took an oath to the Constitution, and that act actually is supported by the Constitution. It all supported together.
Should I draw up a affidavit with this act in it?
No, you can use it in a motion. Type up a motion and you can cite that act in a motion, and then you call them out on the part where state. You can quote certain things in that motion in that act. When you read that act, you'll see what you're gonna need, what you can pull out of that act and quote it in your motion. Okay. And then you call them out as far as like making them prove that the state actually have the evidence. They have to make them present the evidence that gives them authority to get involved in a private matter.
Okay.
The way you upbring your child, the way you raise your children, have nothing to do with nobody. That's between you and the baby mama.
So it says
y'all have the right to raise y'all children the way y'all want to, without the interference of any of these courts.
So this is the summary from S.984, 104th Congress, 95-96, from 1995 to 96, introduced in Senate in 6/29/1995, Parental Rights and Responsibilities Act of 1995 prohibits the federal government or any state or local government or any official of such a government from interfering with or usurping the right of a parent to govern the upbringing of a child of the parent.
Exactly.
This allows any demonstrate, which is prove, appropriate evidence, by appropriate evidence, that such interference or usurpation is valid to accomplish a compelling government interest, in which case only the least amount of interference may be used. So they took way too much control.
That's my point. That thing is very clear about what it's saying. They don't have no fucking evidence. If you ain't got no evidence to get it to prove that, then with compelling evidence, as it says, that you are so. If you read further than that, it's gonna tell you. It's gonna state exactly what I said about the decisions you making can be result in physical harm, serious physical harm to that child, or is a threat to that child's life. It says those specific words in there. As you continue reading on in there, it is very direct and straight to the point. And it says in there, straight to the point, that you can cite, you can raise that act as a defense or a claim in any proceeding. As you continue on, you will see it yourself, and you can use that as your defense. You don't have to register no name and all that stuff. You don't have to if you don't want to, but you can use that act to get them off your ass. They don't have evidence. They never had jurisdiction. They never had authority to to force you into no contract that you didn't want to be in.
Right.
And you have the right, and the Constitution says that you have the right to contract or not contract. If you choose not to contract, nobody can force you into a contract. A contract is not even valid if it's forced anyway. If I put a gun to your head and make you sign a contract, I can't use that contract to enforce nothing.
Okay. I'm gonna get on this one. I'm gonna type up a motion for this.
Yeah, that's all you need, man. You force them to have the evidence. If they don't have evidence, and they need to, then that judgment is void. That's by way of Rule 60B. The judgment is void because the courts never had evidence. They never proved by way of evidence by pursuant to the Parental Rights and Responsibilities Act of 1995. Pursuant to that act, they must have compelling evidence that you are actually of threat to that child's life, or can cause physical harm, or can or have caused physical harm to that child. Other than that, they have no jurisdiction, so that judgment is void. They can't put you on no damn child because they want to get paid off of it.
Yeah, man. Let me get on this motion, man, because the brother, me and another brother working on it. He working on his in Carolina, and he just called me. They sent him a letter to court. He got to show up to court on May 17th. So I said, man, all you got to do is go in there and do what Emno said, man. They got to show evidence that you signed a contract, and then this, I'm going to tell them this.
No evidence that your point, man. You ain't got to say, showing evidence that I signed anything. You ain't signed shit. They ain't got nothing to do with nothing you did. They got to prove their case. They drug you in there.
Okay.
So if somebody dragged you in there, they got to have proof that you did something wrong. Remember, most cases, in order for there to be, there's supposed to be an injured party any fucking way. Ain't no injured party. Ain't no child hurt.
Right.
The state does not have, they don't have interest in it. They only obtain interest when there's an injured party. The child is not hurt. You have not hurt the child. The decisions you make are not going to result in an injury to that child nor that child's life. If they have any evidence, they can't make those claims without having evidence of that.
Right.
Evidence of that. If they don't have evidence, the case is closed. It's that simple.
Let me type. I'm ready to type this motion up. I'm on fire about this. That's fire, man. That's fire right there.
Put it together and keep me posted, man.
Okay, brother.
All right, bro. Talk to you later.
What's your channel? What's your channel?
Top Dad Discussions.
Top
Dad Discussion.
Top Dad Discussion. Okay, I got you.
Top Dad Discussions.
Oh, okay, I got you. Okay.
Yep, I'll send you a link.
Okay. Thank you, man, bro.
No problem, bro. All right, bye.